Welcome to Shareholder Primacy from Free Float Media, a podcast about activist investing, securities law, and all the ways the financial and legal worlds intersect and collide in real life. I'm here with Ann Lipton, a law professor at Tulane in New Orleans, who teaches and researches securities and business law. She holds up the legal end of our podcast.
And that's Mike Levin, an activist investor who lives and works in Chicago. He covers the financial side of our podcast.
Well, Ann, good morning. Let's look at a couple of fascinating subjects. First, with all the SPAC and de-SPAC and other deals, we can look at shareholders can and cannot, the rules for how shareholders can sue companies over basically busted deals.
Problematic ones, anyway.
Yes,
and
exactly.
We'll also talk about Tesla and the other big pay case there, which is not the pay case about Elon Musk, involving its board of directors.
Terrific. Well, let's go over what I'm learning is Section 10B, and a fascinating case then. Actually, there's a couple of recent cases that illustrate developments in both what the courts think and consequently what Congress and the SEC thinks about the various parties to securities lawsuits. And I want to mention now that there is there's some application to how investors generally and activist investors think about this as litigation becomes a much more or an increasing feature in litigation in activist projects. So before we get to the cases, why don't you school us for a minute in Section 10B, whatever that involves.
Section 10B is the big overarching federal statute that prohibits fraud in connection with any purchase or sale of a security. And the SEC can bring enforcement actions under it, but it's also used by private plaintiffs who claim they were defrauded.
Okay, so that's what in federal statute allows folks like me to sue companies, whether they're public or private or whatever,
exactly,
over alleged securities fraud.
That's right.
All right. So if I'm and I've never done this, but lots of other people have.
And I used to represent them.
Yeah, right, exactly. Well, so if you're a plaintiff in one of these cases, what do you have to kind of show to, forgetting the elements of fraud, but what do you have to show to like be a plaintiff here?
Well, yeah. So you actually lose the elements for it. There are different elements to bring up case specifically under Section 10B. First, that there was some kind of deception, usually that someone said something that wasn't true. Second, that whatever they said was important. The legal term is material, but it just means the misstatement wasn't about something irrelevant, it was about something that matters. They also have to show that whoever said the false thing did so intentionally. This wasn't an accident. Fourth, the false statement has to be made in connection with a securities transaction. It wasn't a misstatement about some other thing. 10B is about securities fraud specifically. The plaintiff, the investor, has to have relied on the false statement. That's going to be very important. It's no good arguing someone committed fraud, but you didn't actually believe them anyway. You have to have taken them seriously and acted on it. And finally, you have to show damages. You suffered some kind of economic loss that's traceable to all this. So any plaintiff bringing a claim under Section 10B needs to show all of these things in order to win their case.
All right. So there's a very long list of facts that a plaintiff, basically an investor, has to bring up and prove kind of happen. You just listed, kind of five or six of them.
Six, yeah, and then they have to be pleaded as well, right at the outset.
Right. Oh, exactly. So the parties could agree. You don't have to dispute these facts sometimes, but frequently there's a lot of disagreement about the facts, and that's what some of the evidence and the hearings are all about. All right. So the cases we're going to talk about in a moment. Turn on or have developments related to suing private companies versus public companies, and that's gets to be relevant with some of the SPACs and de-SPACs I know. So what's the why is that difference kind of important to us here?
Okay, so the difference when you're suing a public company versus a private company, a critical issue is reliance. Okay, so in any 10B case, the investor needs to show they relied on the false statement. And for a private company, investors who are investing in a private company, they get diligence materials and they can sue if those materials were false. But when you're talking about a public company, showing reliance is hard because investors make decisions on information that's filtered third hand. The company says something false, analysts hear it and recommend a buy. Investors who never heard the false statement rely on the analyst recommendations or the Jim Cramer report or the Wall Street Bets posting or whatever it was.
Right,
and so they're
not social media.
Yeah, so they're not listening to the actual statements that the company made. And then there are investors who are indexed and they're not relying on anything. They're just buying at the market price.
Right.
So these open market investors may have trouble demonstrating that they personally relied on whatever the false information was that the company's putting out. But it seems fairly obvious that if a publicly traded company reports false earnings or something, some contingent of active investors is going to read that and trade on it, and that's going to influence the market price. So anyone who buys at the market price, even if they didn't read the statement personally, is going to be relying sort of indirectly on that false information. So courts came up with a special rule for public companies. When a company is publicly traded in an efficient market, we'll presume that any false material statements affected the company's stock price, and investors are deemed to rely upon the false statements if they buy at that price. So you don't have to show reliance on an investor-by-investor basis. The mere fact that this public information is out there is presumed to influence market prices, and therefore investors can show reliance if they bought at the market price. That's how public company fraud claims proceed.
All right. So, and we'll get to the specific cases in a second. But then, what sort of problems do investors encounter when they sort of make this reliance? I suppose.
Well, yeah, but one particular problem that's been coming up and it's been brewing for a while is this. The presumption of reliance, which is called the fraud on the market doctrine, by the way, has no logical limiting principle. So lots and lots of different kinds of information might be considered material to an investor's decision to invest, and then it becomes fair game for a securities fraud claim. For example, ordinary product advertisements. It's not an earnings report filed with the SEC, it's an ad aimed at consumers. But investors might use that information when deciding whether to buy or sell. There's evidence that some do use that information. And their trades affect prices for everyone else. Now, suddenly, ordinary product advertisements can be the subject of securities fraud claims. And then it goes further. Let's say you know Coca-Cola is having a problem with the price of bottles. It's likely that
caps,
maybe Pepsi. Then you know if Coca-Cola is having a problem with bottle pricing, probably Pepsi is going to have a bottle price problem. And you might very well assume, Coke announced bottle price problems, therefore I'm going to trade Pepsi. That means if Coke lies about its bottle prices, Pepsi investors may factor that into their judgments about Pepsi, which will affect Pepsi's stock price. Does that mean every investor who bought Pepsi stock gets to sue Coke when Coke lies? And that's not just a weird hypothetical. It just came up in this one case brought by the SEC. An employee of a pharmaceutical company learned his company was going to be acquired. And he also knew that when one company announces it's a merger target, similar companies are viewed by the market as being in play and all their stock prices go up. So he bought shares of a completely different company, not his employer, using this inside information he had about his own company's stock. And the SEC brought a claim against him for insider trading and won at a jury trial. Now imagine if that applies to lawsuits by private plaintiffs. It opens the door to virtually unlimited liability. You may remember, some listeners may remember, 20 years ago when Cendant had that huge fraud scandal. Before that fraud was revealed, Cendant had offered to buy out another company called ABI, and it was going to pay in Cendant stock. ABI's price rose on the news, but then ABI's stock price collapsed when the fraud at Cendant was revealed. The Third Circuit allowed purchasers of ABI's stock to sue Cendant's auditor on the theory that if ABI shareholders could show that Cendant's auditors should have anticipated that their audit report of Cendant would be used by ABI shareholders, then ABI shareholders had a claim against them. But then, and I'd just like to understand the history and the difficulty of this problem,
Yeah.
The Second Circuit had this case involving Nortel, another big fraud telecom company that was part of the telecom bubble. The telecom bubble in early 2000s. Nortel was a customer of a company called JDS Uniphase. So people bought JDS Uniphase thinking, oh, it's getting all this great Nortel business. When Nortel collapsed, so did JDS Uniphase. All the Nortel shareholders, of course, sued Nortel because Nortel had committed fraud, but then JDS Uniphase shareholders sued Nortel, saying you lied about your business. That affected JDS because you were buying JDS products, so it caused JDS stock price to collapse. And they sued, and the Second Circuit said, no, we're not going to let JDS shareholders sue Nortel.
That's a little too far.
Exactly.
That's a little too much.
Statements, right. So all this came to a head in a Second Circuit case that was decided in 2022. There's a company called Frutarom. I hope I'm pronouncing that correctly. I don't know.
Frutarom. Yeah, Frutarom, right. I saw that.
Okay. Was an Israeli company, and it was acquired in a stock-for-stock deal by an American company, IFF. IFF issued its own new stock to make this acquisition. And the intention was that its stock would be publicly traded. And because IFS was issuing new stock that was going to be publicly traded, it had to register those new shares with the SEC. That document that IFF filed with the SEC was technically a prospectus for the sale of IFF shares, a written offer to sell IFF stock. It was selling it to buy Frutarom, and then it would be publicly traded. And because this was stock issued in a merger, the prospectus had all this information about Frutarom that had been drafted by Frutarom. And it turned out it was a lie. It was all a lie. Frutarom was lying.
It was all fabrications.
It was
fabrications. Frutarom.
Exactly.
Right.
So purchasers of IFF stock said, hey, this was false information supplied by Frutarom in the prospectus for buying IFF stock. We should be able to sue Frutarom because by lying about its own business, it misled us in our understanding of IFF. And the Second Circuit said, nope, even though those statements...
You can't do that.
It appeared in the prospectus for the sale of IFF stock, but they were statements about Frutarom, and IFF purchasers can't sue Frutarom over them. This seems absurd to me. The statements were in a prospectus. It's a sales document by definition.
Right.
They were designed to be read by IFF investors. But I also understand the Second Circuit's problem here. So where do we stop? At what point can Pepsi shareholders sue Coke because Coke lying about its bottle prices affects Pepsi prices? And this was the basic problem that we're walking into.
All right. So, and Fruiter, and you wrote about this within the past couple months. Mm-hmm. This then extends into an area that a lot of activists have been focusing on, which is SPACs and de-SPAC kind of companies. So let's go help me here.
Yeah. So you see the implication. A SPAC is just a shell entity. It's a publicly traded company, but it has no business at all until it identifies a private company to acquire. Once it acquires that private company, the private company becomes publicly traded. So a SPAC is just an alternate route for a private company to go public. But there's this interim period. The SPAC is still trading publicly. It's identified a target. And then when it actually goes and before the actual merger happens, the SPAC shares should trade on an assessment of the value of the private target company because the SPAC shares are going to become the target company. And we all know there's been, shall we say, over-enthusiastic hyping of these private companies.
A little bit.
The whole space has this reputation of irrational exuberance. Often, right after the merger, the private company goes public, the whole thing collapses. Allegedly, in some cases, due to fraud. So you see where this is going. Shareholders hear a SPAC is going to buy a promising private company. They buy shares of the SPAC. Then the SPAC merges, the truth comes out, and the price collapses. So these shareholders sue, and they say, hey, I bought the SPAC shares based on these fraudulent statements about the target. I should get to sue the target. And now there's this Ninth Circuit case. It was called Max Royal versus Ativa, and it's actually about the SPAC that took the car company Lucid public. And the Ninth Circuit held, tough! You bought your shares prior to the merger. At that time, they were two separate companies. You bought shares in the SPAC. You can't sue Lucid for lying about its business if you only bought the SPAC. So on the one hand, I get the Ninth Circuit's concern here about this slippery slope. Investors could sue anybody for anything. It's one company suing over statements about another company. But it's a SPAC! Its sole purpose is to acquire a private company. It's absurd to say that statements about the private companies aren't statements about the SPAC. The SEC even adopted these new rules for SPACs, and it explicitly says that the private company should be considered a co-issuer of stock with the SPAC. So this entire SPAC case, as you know, has gotten very, very sketchy, and the Ninth Circuit just opened the door to more abuse.
Right. So activists like me who are looking at busted SPACs, basically, or de-SPACs, that want to, as I said when we introduced this, want to litigate some of this, which is a way for us increasingly to start to put pressure on companies, are going to be a little limited, it appears.
Yeah, and that's
in our ability to do that.
Exactly, and part of the reason you want to sue the target and not the acquirer is because it's often a lot easier to show that the target intentionally lied. The acquirer knows less about the target's business. It's not always obvious that the acquirer knows anything. So you have to make the target a defendant as a practical matter, except now apparently you can't, not prior to the merger anyway, not if you bought prior to the merger.
Right. Oh, so activists that want to try to kind of put that pressure have to keep that in mind.
Exactly.
When they start to think hard about not just owning a SPAC, but what the recourse would be once the share price kind of died.
Exactly.
Oh man. I learned something today. This is really this is going to be something else when I look at my SPAC, and I have a couple. Again, there's a whole range of things activists can do, but this is an increasingly important way to try to pressure companies. So
and so I mean, a lot of the litigation has moved into Delaware in the corporate space, in part because the federal space has just become so limited.
All right, so this is going to potentially limit some of this litigation, but are there other implications we should mention?
No, I mean, it's really interesting to wonder what happens next. I mean, I think this is such a questionable ruling. So I wonder if the plaintiffs would want to go to the Supreme Court over it, but then I don't think the Supreme Court is terribly friendly to securities litigation right now. And the SEC really is sort of limited. It changed its rules for by treating SPACs as the target company as a co-registrant with the SPAC, but that won't affect this kind of litigation, and there's not a whole lot the SEC can do unless Congress steps in. And sure Congress can step in.
So the recourse here would be either the Supreme Court or Congress, and either are pretty unlikely at this point. Oh man! All right. Well, let's think about that. Take a quick break, and then we can return in a minute, and we'll talk about Tesla and director pay here at Shareholder Primacy.
This is the Free Flow Media Podcast Network, where we cover the who of the business news, because investing isn't a what, it's a who. Check out our other podcast, Business Pants, for fact-based snark covering companies and executives, and the Proxy Countdown, the only podcast that treats company meetings like sporting events. Find them on iTunes, Spotify, or wherever you get your podcasts. Back to the show.
Welcome back to Shareholder Primacy. I'm Ann Lipton here with Mike Levin. And so we have once more Into the Breach with Tesla, this time related to its other big compensation case. It's a really big case, except that Elon Musk's case overshadows this case. And this case of compensation involves its board of directors.
It does.
So, I would say we promised not to talk about Tesla again, but we're totally going to talk about Tesla again. It's actually inevitable. So they just do too many wacky things.
It's the gift that keeps on giving.
From a corporate professor perspective, it absolutely is. So what is this case about? It's not Elon Musk's pay.
This case is not about Elon Musk's pay. This case is about what the directors at Tesla paid themselves over a period of 4 years from 2017 to 2020. And a different plaintiff. The plaintiff in the Musk case was a guy by the name of Tornetta. Mm-hmm. The plaintiff in this case was a pension fund, the Police and Fire Pension Fund of Detroit. So we'll call it the Detroit case.
Okay.
And in 2020, they sued the directors and said, we think you overpaid yourself. And they made all sorts of horrible allegations about the kind of money that they were taking out of the company. For 2 or 3 years, the case wound its way through Delaware Chancery Court in front of our old friend, Chancellor McCormick, who is, hearing all these. She seems to have adopted the Musk and Tesla for herself.
Well, yeah, actually, they do that. They once they
absolutely.
It would have been Slights, but Slights retired. She reassigned the cases to herself, and
it was great. As you'll hear in a minute, I met her. It was wonderful. They sued in 2020, and then the case kind of bumped along. And then, lo and behold, about a year ago in July, the parties announced a proposed settlement. No trial, no whatever. They just said, okay, we got to a place where we can settle this. And the settlement had two elements. First was a lot of money. The directors were going to return $750 million approximately worth of shares, options, and also cash to the company.
Wow.
So that was a settlement. We said, okay, they agreed. We'll give that money back. Estimates are that it's about a third of what they were paid.
Wow.
In that 4-year period of time. And again, there was a lot of it was Tesla stock, which had done quite well.
That's a hit.
Well, my understanding is it's one of the top couple derivative settlements ever announced in Delaware. So it was huge that way. There was also a second element, which was a bunch of corporate governance reforms. Essentially, the party saying, we're going to make sure this doesn't happen again. Mm-hmm. And there were 3 such reforms. The first was a better process for paying directors. So they're going to have certain committees and hire consultants and look at different things, and there was a process they're going to have to go through. Second was better disclosure. So in the proxy statement each year, when they cover director pay, it's not going to be a little paragraph about this is how much we're paying ourselves, but it's supposedly a lot more detail about that process that I just referred to. So that's nice. Activists or investors are okay. We like, better process. We like disclosure. Ho-hum. Mm-hmm. The third part got my attention. The third part was a mandatory vote by Tesla shareholders on director comp for a period of 5 years. Okay. So they would have the chance to vote yay or nay, up or down, about whether the Tesla directors in fact would get paid for that fiscal period. And I saw that and I sat up. I said, wow, this has not really been done before. The idea of shareholders not only seeing what directors were paid with a lot more transparency, but actually getting to approve it was quite the big deal. And so I saw that. I said, well, this is pretty cool. That would be wonderful. I'd love to be able to vote on director, especially at Tesla.
Right. Well, yeah. I mean, yeah. If shareholders don't approve it, it's considered a conflicted transaction. So yeah, and that
exactly
what makes this vulnerable in the first place.
Yeah. So that was the elements of the settlement, but there was a couple of problems with the settlement, and one of them about the vote at least got my attention. If you read over the settlement, I don't read these things. Again, I'm not the lawyer on this podcast. I don't tend to read these things carefully. I read this one carefully. You could read really easily that the language of the proposed settlement around the vote was, as we would say, not enforceable. It was actually pretty vague and silent, that you could interpret very easily that a negative result of a vote here would be strictly advisory.
So they were offering to settle it with requiring shareholder votes, but the shareholder votes could easily be non-binding on the director.
Yes, correct. Just like executives say on pay.
That's
just
so
like,
weird.
Okay. Yeah. Oh, yeah. Well, it's either weird. There's nothing accidental in whatever happens at Tesla. So I kind of thought, this isn't right. And so I last October or last fall, a year ago, I wrote up an objection to this and filed it with the Chancery Court and said, I think this settlement needs to be revised to provide for a much more stronger enforcement mechanism, in fact, to make the vote binding and make it very clear. There was a hearing on the proposed settlement last October, so I got myself over to Wilmington, Delaware, and appeared before Chancellor McCormick for a hearing and presented my objection. It was kind of fun. I'd never been to Wilmington before. I'd driven through. Had never been in Chancery Court. And it was very pleasant. Chancellor McCormick, I think, was just delighted to hear from a real shareholder. I mean, there's a whole little pantomime they go through. Are there any shareholders in the room?
Yeah.
Kind of thing. And I said, here I am. And so we talked about it, and I voiced my objection, and most of the hearing, related to like the legal fees that the plaintiff's attorneys wanted to collect. They were looking for like $250 million in legal fees, and I'm looking around the room, and there's like 20 attorneys and little old me, and I represented myself.
Of course,
I didn't have a Delaware lawyer. I went as we say pro se.
Yeah.
To argue this, and I'm looking around saying, wow, I'm standing between 15 of these lawyers and $250 million. I'm sure they have bigger things they want to talk about.
Right.
And so we argued it, and that was, like I said, last October. And we wait at this point.
So it's been over a year.
Yeah,
or nearly a year. Sorry, nearly a year?
Yeah, well, it's been over a year since the settlement was announced in July of
and
2023. The hearing was October.
Yeah, what part of I'm wondering if part of the delay was, remember, we were waiting the size of the attorney's fee, because we were waiting on that, the Dell case out of the Delaware Supreme Court about very large attorney's fees.
Yes, they were waiting for the Dell case, which I knew had come out. I hadn't read it. The other thing that happened was the day after the Tornetta decision was announced in January, the very next day. And so here I am. I'm like a party to this case now.
Right.
So I'm getting all the pleadings. I had, was able to file my objection in the famous Delaware file and serve system, which is maddening. At the time, a very friendly clerk had helped me to file it 4 different times. The first filing wasn't double spaced. The second filing didn't list the word count. I mean, there was all sorts of weird stuff. But now I'm getting all these pleadings because I'm a party to it. So, somebody changed firms, and there were 5 filings around that. So I got all that. Anyway, so in the day after Tornetta was announced, in this case, in the Detroit case, Chancellor McCormick sent a letter saying to all the parties in the Detroit case, I know you've all been waiting, and what I understood was that normally there's a guideline that on settlements you get 90 days, and the 90 days had passed easily. So we're waiting. And so the day after, she sends this letter that says, I know you're still waiting. She said, one of the big issues here is your legal fees, the $250 million that the plaintiff's lawyers want. She expects that the arguments, that the reasoning, whatever, on the Tornetta legal fees, which are somewhere in the $5 to $6 billion range, will bear on the arguments for the legal fees in this case.
Right.
So you're gonna have to wait longer for me to decide on the legal fees in Tornetta, and then I will decide on the legal fees in this Detroit case.
Right.
So we're waiting, and then there was one other interesting little dimension to this that we can mention. So about a month ago or so, or a month and a half ago, just out of the blue, a letter shows up from the parties, not from me, from the plaintiff and the defendants, saying, I know we've been waiting, but some of the options that were going to be returned as part of the $750 million, some of those options are starting to expire. And, the first little tranche of options is going to expire, and it's going to change the damages in the case by like $200.
Right.
No big deal. But there's more options that are going to start to expire pretty soon. The next tranche expires like in June of 2025. And we'd like to get this wrapped up.
Yeah, that's awkward because otherwise
before then.
Yeah,
because
if it's not going to settle, if it has to go to trial, they want to run their options.
Right. If there's going to be some, I hadn't thought about that. Ooh, she could totally say, no, we want to try this. No, I don't think. I doubt that's going to happen. My understanding is that once the settlement gets this far, she's not.
That's unlikely, but that
right.
little bit of uncertainty.
Right. So, so she said. So the parties had said. We're willing to sever the legal fee arguments
from the substance
apart from the substance of the settlement, whether the amount is the right number, where $750 million is the right number, whether the corporate governance changes were the right number. And so there's this letter out there, 3-4 page letter. You can find it on the docket. And in the letter it said, and we are aware of no other issues related to the settlement other than the legal fees. And so I then wrote a letter myself and said, wait a minute, folks. There's actually, and I had actually voiced 2 objections. The main one had to do with the vote. There was another one related to the allocation of the $750 million. The settlement was silent as to how the $750 was going to be allocated among all the 10 or 11 directors. And there was a path where you could see, and the other directors that were in this were like Larry Ellison at Oracle and James Murdoch from News Corp and Kimball Musk.
Right.
There's all these defendants, and since there was no allocation stated in the draft settlement, Larry Ellison could pay it for everybody, or maybe Elon Musk.
And Musk could pay it for everybody. Yeah. Oh,
right.
Wow.
And so that would have really created some very interesting and probably really horrible conflicts.
Yeah.
So that was when I wrote my objection, I wrote 2 objections. That was the first one. Anyway, so I said in my letter, no, there's still more going on here. It's as if the parties didn't even read my objection, and I hope that the chancellor has taken mine under advisement as well. So that happened, and again we continue to wait, but there was that little interesting development in the case. Like I said, only about a month or so ago.
Okay.
So.
Right. That sounds really interesting. I'm like,
it's
keep an eye and see if we get an answer.
Right. Yeah. My hope is that an order is forthcoming pretty soon. People have been waiting a while.
Yeah.
And Chancellor McCormick says the amount's fine, but listen to Levin. Take seriously what he says about the allocation and the vote.
One way or another, she'll very likely address you specifically, so that'll be interesting.
Yes. I've been told by the attorneys that were there. I had a couple of other attorneys that were just visiting the hearing, and they said, she'll probably include what you were saying in this. So at least that's my hope. So anyway.
Well, I really hope you get a chance to make some law.
Me too.
Okay, so let's wrap up there. There'll be more that we'll cover next time.
Yes, indeed we will. Thanks. It's been terrific talking about all this. This is Shareholder Primacy, hosted by Ann Lipton and me, Mike Levin. I'm an independent activist investor and an advisor to investors about their activist situations. Ann, of course, is the Michael M. Fleischman Professor in Business Law and Entrepreneurship at Tulane Law School and an affiliate of Tulane's Murphy Institute. You can find Mike at theactivistinvestor.com, and you can find Ann at law.tulane.edu. Our podcast is, of course, produced and distributed by Free Float Media. Thanks for listening. We will talk again soon.